Hello, my name is Tim McMahon, and today I presented on a topic, somewhat of a unique topic that was created over the last 6 months or so, in which I believe now the courts have formally, expressly relaxed the rules with respect to summary judgment. Taking a step back, in the beginning of 2021, a uniform rule for the trial courts was created, and I think the purpose of that rule initially was to formalize a rule that has existed for some time within the commercial division. And the rule could be found in the Uniform Rules for Trial Courts section 202.8G. And that rule essentially required litigants, when they're moving for summary judgment, to provide a material statement of facts, a list of facts that they felt were undisputed. Undisputed meaning they didn't think there would be an opportunity for their opponent to raise a triable issue of fact on that topic. The rule itself required this submission as a separate, concise statement to a moving party's motion for summary judgment. In opposition to that motion, the non-moving party, the opponent of the motion, was required to confront those alleged material statements of fact. And to do that, they could do that in the same format, but they'd have to make reference to certain record sites to raise a triable question of fact, or at least convince the court that this particular statement of material fact was not undisputed. Now, what ended up happening, however, is some very harsh consequences. When the rule was rolled out, it was rolled out in the beginning of 2021, and I think that some litigants, due to COVID and other court restrictions, didn't really grasp the rule entirely. And what happened on a number of occasions is a moving party would attach to their summary judgment this material statement of facts that was not then opposed. And the trial courts, looking at the plain language of the rule, had to make a decision as to how to deal with that. Well, the plain language of the rule required the opposition, the non-moving party, to confront the statement of material facts. And when they didn't, it led many trial courts to decide that those facts were deemed admitted, and in many instances granted that summary judgment on that basis. The rule, while it was harsh, it was also a little confusing for something I had already mentioned, that being that it was different than the commercial division rule. The commercial division rule didn't use the word shall, it used the word may, and it provided more discretion to the trial court to provide a remedy for one party's failure to comply. In light of all this, the rule was recently amended, and it was amended in July 1st of 2022, just about 18 months later. And what that rule finally did is it provided the discretion back to the trial court to determine what to do with one party's failure to comply or oppose the statement of material facts. But the consequences are still there, right? So the concern, I think, is that if your motion was granted during this time period, what's going to happen next? How is this going to affect you? Or more importantly, what is the appellate division going to do when it's confronted with an order in which a trial court granted a summary judgment motion because of one party's failure to comply based on the plain language of a rule that no longer exists? Well, relatively recently, the Third and Fourth Department have been heard on this issue. The Third Department case can be found at Lieberman 207 AD 3rd 850. And the Fourth Department case is very new, just decided 2 weeks ago in Smith versus MDA 2022 Westlaw 1684750. And these cases basically determine that despite the harsh and mandatory language in these rules, that the court should be given the discretion that the new rule allows for. So in light of this, in light of the fact that it's highly unlikely that the appellate divisions are going to interpret the rule as it was written during this 18-month window, what should you consider? What should you do if an order that you were successful on in getting summary judgment finds its way to the appellate division? Well, keep in mind that you can raise alternative grounds for affirmance in the appellate division, even though the trial court didn't necessarily pass judgment or rule on those particular issues. They need to be preserved. They need to be raised before the trial court in order to raise them on appeal. But that is a way in which you could still get the same result for possibly a different reason. So it's important to keep that in mind. If in fact you were successful before the trial court on the issue of a statement of material facts, but yet the lens or the rule has since been amended and modified. Other considerations to keep in mind, of course, are the idea that courts can still, individual judges can still require material statements of fact. Now, they still have the remedy of applying their own discretion of how they will treat the statement of material fact, but it's important to know that despite the non-mandatory language in the uniform rules and the absence of any language in the CPLR on this topic, that individual judges can still require a statement of material facts as part of your motion for summary judgment. So in making your summary judgment motions, I think you need to start with the CPLR. You need to then move into the uniform rules. And then, of course, you need to check your individual judges' individual rules before making that motion for summary judgment. It's been a pleasure introducing this topic today, and I hope that you have the opportunity to tune in to the full webinar. Thank you very much.